Welcome to transnational competition law classes. And dear learner and viewer, we have discussed with you very important lecture on the aspect of transnational competition law, and we particularly emphasize upon the point that what are the basic difference between the enforcement of extraterritorial application of competition law and what is the embarrassment of competition law. After having a very fruitful discussion on the enforcement as well as embarrassment of extraterritorial application of competition law in developed and developing countries, we try to grapple the very difference between the enforcement and the embarrassment, and in the embarrassment of extraterritoriality in developing and developed and developing countries, we made the focal reference of United Nations study on developing countries' experience with extraterritoriality in competition law published in 2021. And we realized the fact that how out of the random survey of the 40 countries, 34 countries have embraced extraterritorial application of competition law in their domestic competition laws and policy. We have taken example from the United States. We have taken example of Latin American and South American countries. We refer to the example of the European Union. We refer to the example of South Africa and African countries. We also refer to some Indian jurisdictions. We refer to some of the West Asian countries and Russian Federation. And what we try to bring home to the conclusion that even if the countries happens to be very proactive in adopting and embracing the extraterritorial application of competition law, we have a parallel mechanism of governing the competition laws and policy under the international law, be that the soft core international law or hardcore international law. Dear learner and viewer, we have studied and we have referred the United Nations Conference on Trade and Environment contribution to the development of international competition law. We have referred to the United Nations Conference on Trade and Development set of multilaterally agreed equitable principles and rules for the control of restrictive business practices. We also refer to the United Nations Conference Restrictive Business Practices Resolution 1980. We also hinted about the United Nations General Assembly 1980 resolution, which is called as United Nations Set of Principles and Rules of Competition, and its vociferous recommendation for the purpose and effect test in determining the extraterritorial application of competition law. And we also tried to preface some of the basic thrust of the United Nations Conference on Trade and Environment, United Nations Conference on Trade and Development model law on competition that uses the UN set law as a primary base to further foster competition law across all developed and developing countries. Now, today, dear learner, we will be focusing specifically the Organization of Economic Cooperation and Development's competition laws and policy, and we will try to reflect upon the fact that how Organization of Economic Cooperation and Development have heralded a competition law and policy and in sector specific studies and very cogent policy recommendations, how the Organization of Economic Cooperation and Development have been very active in documenting the sets of soft law recommendations within the Organization of Economic Cooperation and Development countries. Moreover, we will also look some of the salient features of Organization of Economic Cooperation and Development Council's recommendations of 1995, which have specifically developed and targeted to fight against anti competitive practices. We will also be looking at the Organization of Economic Cooperation and Development Council Recommendation 2014, which encompasses the competitive investigations and proceedings. Then, dear learner, we will be devoting to that what has been the seminal contribution of International Competition Network, and we will look how the final report of the International Competition Policy Advisory Committee of 2000 have made great impetus in promulgating the competition law and policy, especially the extraterritorial application of competition law in the developed and the developing countries. We will also be looking at very critically that to what extent the international competition network have been a real international forum that may be a non-governmental or voluntary organization and have tried to shape and guide the policies relating to competition law. In that context, dear learner, we will be thoroughly examining the contribution of International Competition Network as a voluntary and non governmental organization and not an intergovernmental organization to act as a virtual and informal kind of institutions and administrative setup to pursue some of the mammoth contributions and mammoth notifications on the competition law. We will also be examining in detail that how the International Competition Network have been one of the very cardinal agency in the consolidation and simplification of the cooperation between the various authorities on competition and promotion, how it tries to pull out and how it tries to consolidate and uniform the competition law and policy to give some kind of augmentation and expanding economic growth across developed and the developing country. We will be especially appraising the International Competition Network's Statement of Achievement 2010 to ascertain the degree of practical techniques of enforcement as well as the issue of the embarrassment of the competition law among the developed and the developing countries. And we will finally conclude to the point, dear learner, that International Competition Network, despite being not an intergovernmental organization, despite not having any kind of United Nations backup and not having any kind of a very formal kind of the organization, have drastically set the tone and direction of the harmonization of antitrust and competition law, and the soft law have been handed down under various jurisdictions in building a very cohesive and a coherent competitive market across the globe. With this, dear learner, we'll be directly hitting hard to the point what we can refer to, that is relating to the international competition network under the embarrassment of the extraterritorial application of competition law. In this regard, it is very salubrious to note that Organization of Economic Cooperation and Development, competition law and policy drawn from the Organization of Economic Cooperation and Development overarching competition law policy and the policy committee, which has been as one of the overarching organization to see that how antitrust and competition law happens to be a reality among the domestic and as well as international market. We will be referring to that how Organization of Economic Cooperation and Development, competition law and policy committee is really an international forum at the international level for addressing and resolving all kinds of issues which relate to competition law and policy. In this regard, we see that the Competition Committee of the Organization of Economic Cooperation and Development organizes a series of the sector specific studies to look at how the competition law in the context of abusive behavior, cartelization, predatory prices, and anti competitive behavior works in the market. It also, the Organization of Economic Cooperation and Development comes out with a very viable and effective policy recommendations, and it lends great support to the government of the countries to improve their existing antitrust law and to refurbish their antitrust and the competition law regime. The OECD, Organization of Economic Cooperation and Development Committee, has also contributed to a great extent to the issuance of a series of reform and the sleeve of the soft law document, and which has submitted a large numbers of recommendations on various antitrust policies and topics. If we look at the present corpus of the soft law and the slew of reform which has been done in this direction, we find that all the topics relating to antitrust and the competition law happens to have an interface with the Organization of Economic Cooperation and Development. The Organization of Economic Cooperation and Development Council recommendation 1995 is said to be a milestone in this direction because it tries to directly address the issue that how the conduct of some of the multinational companies in the international market tries to infiltrate the anti competitive practices, and the Organization of Economic Cooperation Council recommendation 1995 in its right earnest try to combat the entire strategy of fighting the anti-competitive practices which are prevalent in the international market. The Organization of Economic Cooperation and Development Council's recommendations of 1995 also try to replace and refurbish the Organization of Economic Cooperation and Development Council recommendations of 2014. So, the entire legislative development from 1995 to 2014, almost the two decades and 20 years of intense negotiation and intense legislative exercises and intense drafting, the Organization of Economic Cooperation and Development dealt all the varieties of issues which pertains to the cooperation, goodwill building, and trust building at the international level. And in this reference, we can refer to the competitive investigation and proceedings which has been developed by the Organization of Economic Cooperation and Development in 2014. Here, it will not be inappropriate to look a very holistic manner that as to how the organization of economic cooperation with the plethora of laws and recommendations and policy briefs have greatly influenced the embarrassment issue of the extraterritorial application of competition law. Dear learner, it will be at this juncture, it will be a great loss if we will not be referring to some of the very important proceedings and contribution of organization of economic cooperation and development. In this respect, dear learner, we have to refer to the recommendations on the competition policy and exempted or regulated sector, which has been passed as far back as 1979. In analyzing the recommendation on competition policy and the exemptions and regulated sector of 1979 gives a very clear picture and image that the competition laws and policy, especially the extraterritorial application of competition law and policy, has been a subject of intense discussion and the focus of Organization of Economic Cooperation and Development right from 1970 down to this day, meaning thereby it happens to be a kind of a contribution of almost 50 years. During the last 50 years or half a century's intense preparation and meticulous engagement of Organization of Economic Cooperation and Development leads to some of the very important and fruitful discussions and recommendations. So we can refer to recommendation on competition policy and exemption and regulated sector that provides a kind of a panorama that how the embarrassment issues of the extraterritorial application of competition law can be triggered off and can be ticked off. In this respect, it will also be very important and helpful to turn our discussion to the recommendations which concerns the effective action against hardcore cartel which has been passed by the Organization of Economic Cooperation and Development in 1998. Then we will be taking recourse to the Organization of Economic Cooperation and Development's contribution in recommending the merger review in 2005, and which we have noticed throughout our discussion on the enforcement and embarrassment of extraterritorial application of competition law, that the most of the problems and hurdles and hiccups which are being faced by the companies happens to or pertains to the offshore merger and the merger review. So the recommendation concerning the merger review 2005 by the Organization of Economic Cooperation and Development happens to be a kind of a milestone to guide all kind of the embarrassment and the enforcement of extraterritorial application of competition law across the global scale. The Organization of Economic Cooperation and Development has also been very industriously involved and meticulously involved in honing out the best practices on information exchange. Dear learner and viewer, it is at this juncture we can realize the very essence and the spirit that most of the issue of the enforcement of the competition law in developed and developing countries pertains to the procedural law, the service question, the evidentiary values, the summons, the notification, the publication. In this respect, that Organization of Economic Cooperation and Development's uh, publication on the best practices on information exchange, because there are many countries who are not in a position to have the information exchange, And there are many countries which has been ruthlessly subjected to the evidentiary value, and it has been observed that it happens to be beyond the capacity of some of the countries to corroborate and adduce the evidences, and they are not in a position to seek the evidences which are required in their jurisdiction. I think, dear learner and viewer, the Organization of Economic Cooperation and Development's publication on best practices on the Information Exchange 2005 will be of a great help in the armory of the competition lawyers and advocates to see that how the issue of the enforcement and the embarrassment of the competition extraterritorial application of competition law can be made effective and in the real sense and the real world scenario. Then we will be referring to the Organization of Economic Cooperation and Development's publications and effort in bringing the guiding principles for regulatory quality and performance. So, the Organization of Economic Cooperation and Development is having a very pragmatic perception of the issue of the enforcement and as well as the embarrassment of the extraterritorial application of competition law, putting great emphasis not only some very random and stray guiding principle, but it believes that how the quality of the legislation, the quality of the drafting, the quality of the contractual terms, which determines the entire performance of the firms in a globally competitive market, that has been prepared by the Organization of Economic Cooperation and Development guiding principles for regulatory quality and performance in 2005, and it is being quickly followed by a recommendation on the competition assessment, that we have to see that what are the impact of the enforcement of extraterritorial application of competition law, and what happens to be the embarrassment of the extraterritorial application of the competition law. And we will try to see that how these legislative changes at the domestic level, at the regional level, at the national level, and as well as international level is having some kind of some benchmarking, having some kinds of parameters, and having some kinds of qualitative check. That can only be possible if we engage into a kind of an impact study or the assessment study. In this context, dear learner and viewer, the recommendation on the competition assessment and review happens to be of great importance, which has been developed by Organization of Economic Cooperation and Development in 2009. Uh, Followed to it, we find a recommendation of a great importance, that is the recommendation concerning a structural separation in regulated industry, meaning thereby that these laws which has been passed have been regularly has been qualitatively checked on regulatory aspect and performance aspect, and then having an assessment and audit of the working of the extraterritorial application of competition law, we will see that what are the structural separation which is possible, and what kind of the industry and the firms are there who happens to play in the competitive market at international and domestic level in matters of anti-competitive behavior, abuse of dominance, regulation of combination, review of the merger, predatory pricing, rule of reason, how all these policies, which happens to be a kind of a policy, broad policy, and the legal policy under the competition law, that I think that in that context, the recommendation concerning structural separation in regulated industry of 2011 will be a great help in understanding the entire issue of the enforcement and as well as the embarrassment of the competition law. Then the Organization of Economic Cooperation and Development's recommendation on fighting bid rigging in public procurement is also very important because be that the predatory prices or the price fixing or the cartelization and which have a direct impact on the bid rigging and public procurement in the competitive market at the national, regional, global level. The Organization of Economic Cooperation and Development's recommendation on fighting bid rigging in public procurement in 2012 happens to be the another very important kind of the soft international competition law which have a ripple effect on the entire purview and discourse of the enforcement and as well as embarrassment of extraterritorial application of the competition law. Thus, dear learner, if we look at the seminal contribution of the Organization of Economic Cooperation and Development's competition law and policy at national, regional, and the international level, we can safely say that it happens to be a landmark step towards promoting international cooperation among all competition authorities, and thus it reduces the harm done to the market and by protect all the market from anti-competitive agreement and regulation of combination. A study of all the recommendations which has been handed down by the Organization of Economic Cooperation and Development in the form of the guideline happens to be the soft principles of international competition law have very brilliantly dwelled on the multifarious aspect of the competition law and have given a very loud thinking in matters of the competition law enforcement, especially the enforcement of extraterritorial application of competition law in developed and developing countries in more than one way that the entire soft law development of the Organization of Economic Cooperation and Development is moving from a general and a generic sense of the competition policy to the bid rigging, to the public procurement, to regulated industry, to the structural separation, to the competition assessment, to the regulatory quality, to the regulatory performances, to information exchange between the state, to a study on the merger review and effective action against the hardcore cartel and all kind of exemptions which are enjoyed by the firms and the multinational corporation. So we see that from general to a specific and to the core of the competition law, probably all the important issues have been touched upon by the Organization of Economic Cooperation and Development in a slew of soft law preparations of the guidelines of the competition law and the antitrust law. With this, dear learner, what we can safely conclude ultimately, when we talk of the embarrassment of the extraterritorial application of the competition law, we can safely conclude to the point that the embarrassment of the extraterritorial application of competition law is a kind of a concept which has been developed and have been embellished by the United Nations Conference on Trade and Environment, Organization of Economic Cooperation and Development, and International Competition Network. And with this, dear learner, I just end my lecture here. and we will be more devoting to the aspect of international competition network and its very cardinal role in promoting the embarrassment of extraterritorial application of competition law in the developing countries. And I hope the entire notion of the embarrassment in the context of the national law, in the context of United Nations Conference on Trade and Development Law, in the context of Organization of Economic Cooperation and Development, and in the context of International Competition Network, we can understand we can have a very holistic perception as to what exactly mean by the embarrassment and how that the any kind of the vacuum and any kind of the gap which has been found in the national competition law are to be immediately filled up by the United Nations Conference on Trade and Development, Organization on Economic Cooperation and Development, and International Competition Network agencies to see that how the enforcement as well as embarrassment of the competition law in developed and developing countries survive survive and thrive very smoothly. Thank you, dear learner, and have a happy learning. Thank you very much.